Hi and Assalamualaikum everyone, especially to our respected lecturer, Madam Mazlina binti Ahmad Zayadah. First of all, I want to introduce our group members, which consists of 5 persons, which are Afina Zulaika binti Yaakob, Nur Izzaty binti Mat Nasir, Nur Khaliesa binti Osman, Nur Akifa Ayuni binti Kamarul Zaman, and Qaisara Batris binti Ridwan. This is our group video presentation on the current issue for the subject HRM659 Industrial Relation. Our group has chosen the following two articles as our current issues portfolio. So for the first article is about ex-consultant awarded 221,000 for constructive dismissal. And the second article is about Hilton Kuala Lumpur offers employee retention program and retrenchment. Next, I will pass to the next presenter, Qaisara.
My name is Qaisara Bakris and now I will present about the first article, which is ex-consultant awarded 221,000 ringgit Malaysia for constructive dismissal. The article is about constructive dismissal. K. Trava Pregesh claimed to the industrial court that he was constructively dismissed by Metric Power Network, which is the company where he worked before. This is because the company failed to pay his salary and postponed in paying the necessary statutory deduction for income tax, EPF and so. The industrial court stated that the claimant has been constructively dismissed by the company and the company failed to prove that the claimant's assertion of constructive dismissal is not true. Therefore, the company must pay the back wages of 191,250 and compensation amounting to 30,000 in lieu of reinstatement to claimant as a remedy of this case. The main issue of this article is constructive dismissal. The factor of claimant claim constructive dismissal is due to the company action of delay in paying EPF, SOCSO and income tax, where it also lead to a violation of terms and condition of the employment contract. As mentioned by Ho, constructive dismissal applies to an act of employee to terminate his or her employment with the company due to the breach of employment contract by the employer, which leaving the employee with no choice but to resign. Next, the second issue from this article is the employer has violated the employment contract due to fail in paying claimant salary in a long period of time, which is from February 2018 to May 15. Next issue is the company plan to eliminate the compliance status as a permanent employee, fail to give a workplace for him and remove the official email address of the claimant. Last but not least, the company made a backdated proposal to Teva for a 1-year contract as consultant. Next, I will pass to the next presenter.
Hi, my name is Afina Zulaika binti Yaakob and I will continue explain on the statutory law. The statutory law applicable for this case is Industrial Relation Act 1967. This is because the article is mentioned about constructive dismissal under Section 20 of Industrial Relation Act 1967. The legal issue that has been discussed in this article is K. Tiva Praga's claim to the industrial court that he was constructively dismissed by his employer, which is Metric Power Network, and he also managed to prove that there was a breach of his employment contract whereby the company did not pay his salary and also had delayed his payment of EPF and SOCSO. Therefore, he entitled to claim constructive dismissal. What is constructive dismissal? Constructive dismissal is occurred when an employee contract is breached by the employer. The employee has the right to leave the employment due to the employer undesirable conduct. The employee can make a claim of constructive dismissal to the Department of Industrial Relations and left his employment in a timely manner. Next, I will pass to the next presenter, Khaliesa.
Hi, my name is Nur Khaliesa binti Osman and I will continue on the compare and contrast of this article. It can be seen from 4 things which are constructive dismissal under Section 20 of IRA 1967, employer's obligation, implied duties of employer in contract of employment and contract of employment. First is constructive dismissal under Section 20 of IRA 1967. In the article, the employer breached the contract of employment by not paying the employee's salary for 3 months starting on February 2018 until May 2018. It can be proven when the court finds out that the employer has delayed in paying an outstanding amount of 40,152 ringgit 25 cents towards the employee as its salary during the employee claiming for constructive dismissal to the employer. From what we have learned in class, Section 20 of IRA 1967 states that the employee can claim for constructive dismissal if the employer breached the contract of employment. This is supported by Section 15(1) of EA 1955 that states the contract of employment can be seen broken if the employer fails to pay the employee's salary in addition with Section 18 of EA 1955 tells that the salary periods must not exceed 1 month as stated in the contract of employment. Salary is one of the terms in contract of employment, and this action shows that the employer does not comply with the contract of employment. Hence, there is a constructive dismissal happens and the employer is non-compliant to the IRA 1967. Besides, the employee gave sufficient evidence to the court to show that he has been constructively dismissed by the employer. It is stated in the article that court found that the employee had successfully proven that there was a constructive dismissal because the evidence clearly showed that there was a breach of employment contract by the employer. However, to prove that there is constructive dismissal, the employee must be able to show that the fundamental term of the contract is breached by the employer and left the employment in direct response to the breach as well as in a timely manner. On that account, the employee is compliant with the Section 20 of IRA 1967 on burden of proof for constructive dismissal, as the employee can prove that there was a breach on the contract of employment by the employer and he left the employment in direct response to constructive dismissal as well as in a timely manner, which is directly after he was constructively dismissed by the employer. Second is on the employer's obligation. In the article, the employer failed to pay the employee's EPF, SOCSO, and income tax deductions on time to respective bodies. According to what we have learned in class, if employer failed to pay EPF, SOCSO, and income tax of the employee, he or she can be prosecuted because it is an offence. This is because the EPFA 1991 and ESA 1969 have stated that employer obligated to remit all contributions from the employee and employer to the EPF and SOCSO. Failure to do so will lead the employer to be prosecuted. Moreover, the employer also obligated to remit both contributions from employee and employer by 15 to EPF and by end of the month to SOCSO. These regulations have been mentioned under EPFA and ESA. Thus, this shows that the employee is non-compliant with the laws relating to social security such as EPFA 1991 and ESA 1969 as the employer delayed in paying the contributions to the respective bodies. 3 is on the impact duties of employer in contract of employment. In addition, based on the article, the employer has failed in providing a workplace for the employee as well as has deleted the official email account of the employee, which shows that the employee has a motive to move out the employee from the company and result in breach contract of the employment. From what we have learned in class, employer must provide a good workplace for the employee to do their tasks and duties in a safe environment. Therefore, when an employee does not have access to official email account, it will hinder the employee to perform the task and it shows that the employer did not act in good faith as the employee did not obey the impact duties he must follow. These two things are considered as impact duties of an employer to the employee that need to be adhered. Failure to do so lead to constructive dismissal under Section 20 of IRA 1967 as the employer breached the contract of employment by not obeying the employed terms and duties as stated in the contract of employment. And 4 is on the contract of employment. Lastly, in the article, employer has no intention to make the employee as permanent employee anymore. Thus, the employer offered a backdated offer to the employee, which is a 1-year contract as consultant. This is opposite to what we have learned because contract of employment must be drafted clearly to avoid any issues in the future. Plus, it must be compliant with the law, easily understood by the employees, and all the content must be completely written. Thus, it shows that the employer is non-compliant with the requirement to make a legal contract of employment with the employee because of the backdated issues that is unfair to the employee. That's all from me. I will pass to the next presenter.
My name is Izzaty and I will explain the conclusion and recommendation. In conclusion, the article is discussed about constructive dismissal by Matrix Pabon Network Sdn Bhd towards the employee Tiva Prakash. The claimant claims that the employee's action leading to constructive dismissal at the court. Therefore, the court ordered the company to pay 221,250 ringgit Malaysia to the claimant. The statutory law applicable in this case is IR Act 1967 because the article was discussed about constructive dismissal under Section 20 of the IR Act 1967. Based on what we have learned, we can conclude that employment contract is very important for both employee and employer. This is because employment contract can act as an evidence in the court for any cases related to employee and employer, including constructive dismissal. For the recommendation, an employer should perform his role and responsibilities as a good employer in the company, such as the employer should not delay in paying the salary to the employee. Furthermore, the company also should pay the necessary statutory deduction for income tax, EPF, and SOCSO to the employee who are entitled for it. Next, the employer must strictly follow all the express terms stated in the employment contract that has been agreed between employee and employer. An employer also must provide good and safe working conditions to his employees. Furthermore, the employer also must conduct all the duties and responsibilities that written in the employment contract to prevent any constructive dismissal claimed by the employee. This is because it can affect the reputation and the good name of the company in the future. Therefore, the company must have a good relationship with all the employees in the organization. Next, I will pass to the next presenter to explain the issues on second article.
Next, I will present about the second article, which is Hilton Kuala Lumpur offer employee retention program and retrenchment. The article is about retrenchment. The article mentioned that two hotels in Malaysia, which are Hilton Kuala Lumpur and Shuan Hotel, are suffering because of COVID-19 pandemic. Both hotels are struggling to manage their employee welfare as they are unable to pay the employee wages due to declined profit. Therefore, Hilton Kuala Lumpur conduct an employee retrenchment and offer retention program to their employee, as well as provide 600 ringgit Malaysia as a financial support for 1 to 6 months. Meanwhile, Shuan Hotel in Ipoh informed to their staff that they will stop their operation and resulting to retrenchment. However, the company will provide termination benefits and pay the employee salary, including other applicable remuneration. The main issue of this article is about retrenchment. Hilton Kuala Lumpur will conduct retrenchment since they are struggling to retain their employee during COVID-19 pandemic. As mentioned by Ho, retrenchment is the dismissal of workers who have become surplus to the organization and may occur when the company no longer requires the same number of employees as it used to be, or the employee duties has either stopped or ceased. Therefore, Hilton Kuala Lumpur trying to manage their employee by retrenching some of them based on last in, first out LIFO. Other than that, they also will deduct employee salary based on the latest signed agreement between both parties. As a result, the salary deduction will be 20% or 50% of the employee salary. Furthermore, another issue is Shuan Hotel also retrenched all of their employees during the COVID-19 pandemic. This is because the company will stop their operation permanently on May 31. A total of 155 staff are affected and being retrenched due to the ceased operation. However, the company will provide the employees who are being retrenched with termination benefits in compliance with the Regulation 1980, Employment Act 1955, Employment Termination and Layoff Benefits. Other than that, the company also will be paying all the salary of the employee until the end of their employment, including other applicable remuneration. Next, I will pass to the next presenter.
Hi, it's me again, Afina binti Yaakob, and I will continue explaining on the statutory law for the second article. The first one is for Hilton Kuala Lumpur. The statutory law applicable for the case of Hilton Kuala Lumpur is Employment Act 1955. This is because the article is discussed about retrenchment process according to Code of Conduct for Industrial Harmony. The legal issue that has been discussed in this article is Hilton Kuala Lumpur wants to retrench their employee due to the problem that they faced during COVID-19 pandemic. Therefore, they decided to terminate some of their employees using last in, first out LIFO principle. So what is LIFO principle? LIFO is a common industrial practice to retrench employee, and it is conducted by terminate the most recently recruited employee first. In addition, it recognizes the experience of employee as an important element and support the retention of the old employee who has served for a long period. The second statutory law is for Siyun Hotel. The statutory law applicable for the case of Siyun Hotel is Employment Act 1955. This is because the article is discussed about termination benefit given to the employee who are being retrenched according to Employment Termination and Layoff Benefit Regulation 1980. The legal issue that has been discussed in this article is Siyun Hotel offer the retrenchment benefit to 155 of their employees who have been retrenched due to the closure of their hotel on 31st May, which had been severely affected during the COVID-19 pandemic. The employee of Siyun Hotel will receive their salary, including other applicable remuneration, until the end of their employment on 31st May. So what is Employment Termination and Layoff Benefit Regulation 1980? So, this regulation is only applicable to employees who fall within the scope of the Employment Act 1955, which mainly to the employee whose monthly wages do not exceed 2,000 ringgit a month or those that involve in manual labor. Next, I will pass to the next presenter, Akifa.
Hi, my name is Akifa binti Zaman, and I will continue to present on compare and contrast. For Hilton Kuala Lumpur, we will compare and contrast on Code of Conduct for Industrial Harmony, last in, first out LIFO, Employment Insurance System Act 2017, and salary reduction. Okay, the first one is Code of Conduct for Industrial Harmony, last in first out life 4. Based on the article, Hilton Kuala Lumpur decided to terminate their employees due to the effect of the COVID-19 pandemic. Therefore, they choose to terminate their employees according to last in first out life 4 process. It means that the company will terminate the junior workers first and followed by the senior employee who has a longer service with the organization. However, retrenchment is applied after employee retention program and unpaid leave is implemented. According to Code of Conduct for Industrial Harmony, the employer should only conduct termination exercise after other alternatives implemented to solve the organization problem have failed, and termination of the employees become a last resort. Thus, it can be said that Hilton Kuala Lumpur is compliant with the Code of Conduct for Industrial Harmony as they terminate their employees after some alternative to solve the company's problem have been done. Next, number 2 is Employment Insurance System Act 2017. As stated in the article, Hilton Kuala Lumpur take an action to remind their employees to make claims through the Social Security Organisation for Employee Insurance System EIS. It can be said that this action is aligned with the employee's obligations under Employment Insurance System Act 2017 because it shows that the employer conducts his or her responsibility to remit all contributions from the employee and employer at the end of the month to Social Security organizations also. On the other hand, the employer deducts 0.2% of employee salary and contributes 0.2% of employee salary for the employer's contribution portion at the end of the month to also. In conclusion, Hilton Kuala Lumpur is compliant with Employment Insurance System Act 2017. And the last one is salary reduction. Hilton Kuala Lumpur also deduct the employee salary by 20% or 50%, and the salary reduction is applied to the remaining employees who are not involved in the retention program and termination conducted by the organization. Based on the article, Hilton Kuala Lumpur seem to have a mutual agreement with their employees as the salary reduction is made according to the letter signed agreement. In conclusion, Hilton Kuala Lumpur made a salary reduction after having a consent from their employees and according to the law regulations as well as did not breach the employment contract. Next, for Siyun Hotel, we will compare and contrast on Employment Act 1955, Employment, Termination and Layoff Benefits, Regulations 1980. Siyun Hotel, which is the second hotel mentioned in the article, also decided to terminate their employees due to the effect of COVID-19 pandemic. As stated in the article, there are 155 employees are being retrenched by the company, as the company will stop their operations on May 31. However, the employees who are being retrenched will be given termination benefits by the company. According to the Employment Act 1955, Employment, Termination and Layoff Benefits, Regulations 1980, employees are entitled for the termination benefits if they are being retrenched by the company. Therefore, it can be said that Siyun Hotel is compliant with the regulations as they provide termination benefits for the employees who are being retrenched and entitled for it. So that's all from me. I will pass to the next presenter.
Lastly, I will explain the conclusion and recommendation. In conclusion, the article is discussed about termination of workers by two hotels, which are Hilton Kuala Lumpur and Siyun Hotel. Both hotels had to retrench their workers because their hotels were affected by COVID-19 pandemic. However, based on what we have learned, it shows that Hilton Kuala Lumpur is compliant with Code of Conduct for Industrial Harmony and Employment Insurance System Act 2017 because the company terminate their employees using last in first out process and remind its workers to apply for claims for employee insurance system EIS. The statutory law applicable in this case of Hilton and Siyun Hotels is Employment Act 1955. It can be concluded that both companies are compliant with the statutory law. The first recommendation is the employers should treat their workers that has been retrenched with dignity and empathy. For example, the employers should select the workers for retrenchment fairly, which means they should keep the senior workers and retrench the junior workers first. Secondly, the employers should consider to having a longer retrenchment notice period for all the affected workers. Thus, it will make their workers to be more well prepared with the retrenchment process. Thirdly, the employers can help the employees that has been terminated to look for a new workplace for them. Therefore, it can be concluded that employees must have fair and responsible attitude when they are dealing with retrenchment of their workers. That's all from us. Thank you.